The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. My name is Diana Motz, and you can see me and you can see Judge Agee, and our colleague Judge King is just on the phone, but he's very much with us. We're happy to have you with us. Our first case we'd like to hear argument in the state of North Carolina versus the United States. Ms. Boyce?
Thank you, Your Honor, and may it please the court. My name is Sarah Boyce, counsel for the state of North Carolina. Congress passed the two statutory provisions at the heart of this appeal for the express purpose of empowering states to enforce federal compliance with air pollution laws. For years, federal facilities had undermined the state's environmental efforts, and Congress was determined to put a stop to their recalcitrance. To accomplish that goal, Congress took two steps relevant here. First, Congress added a clause to the citizen suit provision that precludes removal and allows states to keep enforcement actions against the United States in state court. Second, Congress broadly waived the federal government's sovereign immunity from all remedies and sanctions, including punitive fines. This intention is clearly communicated in the plain text of two different provisions, and it is confirmed repeatedly in the Act's legislative history. The court below flouted the clear text of these two Clean Air Act provisions, and for that reason, it should be reversed. I'd like to start with removal, since that's a threshold issue for the court. And before I dig into that, I'd note that the statute I'm about to discuss is at addendum, pages 22 and 23 of the addendum to the state's brief. I've found that talking about this statute in the abstract can be a little complicated, so just note those pages for the court. The United States argues that subsection E of 7604 does not preclude removal because in the United States view, this provision is nothing more than a savings clause. That view is mistaken for three primary reasons. First, it confuses distinct provisions within subsection E. Second, it fails to give effect to portions of subsection E's text. And third, it's inconsistent with a specific versus general canon of construction.
Can I ask you a question?
Sure, Judge Watts.
I hear you with regard to the language of the statute. It does not expressly waive, say that the federal government cannot remove. You would agree with me there, right?
Of course.
Right. Can you point to any other statute that implicitly carves out an exception to the federal officer removal statute?
That does not explicitly carve out an exception, or that does?
That implicitly carves it out. We'd agree that this, your position is this implicitly carves it out. Carves out an exception.
Yes, Your Honor, that's correct. No, Your Honor, as far as the United States is aware, there are only two provisions that use this method of precluding removal, those being the Clean Air Act and the Safe Drinking Water Act. But I would note two things in response to your question. The first is that there are, of course, two primary removal statutes for the federal government, the first being 1441 and the second being 1442. And whereas 1441 expressly requires that Congress preclude removal in express terms if it means to do so, Section 1442 contains no such requirement asking or stating that Congress must preclude removal in express terms. So the courts have drawn a distinction between those two statutes in terms of the specificity with which Congress must speak. So that would be my first point. Secondly, I think this court can perhaps draw some comfort in the fact that these kinds of removal provisions are so rare, being only in the Clean Air Act and the Safe Drinking Water Act, because I think some of the United States' concerns about the federal government being unable to remove in a wide swath of cases and being unable to present these various sovereign immunity defenses in federal court is minimized based on the admitted idiosyncrasy of this provision.
Counsel, if I can inquire, is the Safe Drinking Water Act you're referring to part of the Clean Water Act?
No, Your Honor. These are separate statutes that were enacted at different times, but were revised at the same time that Congress was engaging in all of these different 1977.
If I'm remembering correctly, the Clean Water Act has a specific removal provision in it.
That's correct. Yeah. So the Safe Drinking Water Act is a distinct statute from the Clean Water Act. The Clean Water Act expressly precludes removal, expressly allows for removal, says that the state cannot stop removal from happening, whereas both the Safe Drinking Water Act and the Clean Air Act contain no such provision. So we would submit that Congress's deliberate inclusion of a provision addressing removal in the Clean Water Act signals that in the Clean Air Act, it did not similarly intend to allow.
Well, there was a provision proposed for the Clean Air Act similar to the one in the Clean Water Act, which was not adopted. So what significance do you give to that?
Your Honor, we agree with the Ninth Circuit, which, as I'm sure you know, interpreted that to mean that the removal provision would have been redundant and duplicative, and drew from Congress's decision to remove it that it had decided not to be superfluous. Obviously, the United States has a different interpretation of the omission of the provision, but what we do think is clear based on that is that Congress had removal in the back of its mind when it was revising this provision, such that any argument that the language about any law of the United States, perhaps not referencing the removal statute, becomes more far-fetched. We know that Congress was contemplating both removal and sovereign immunity as potential problems or potential defenses or responses that the federal government might raise. And thus, we think that bolsters the state's argument that any law of the United States in this particular subsection should be construed to reference those federal statutes.
And I'm sorry, not sure I quite understand your answer to my question. Is it your submission that these other statutes that you say, the Safe Drinking Water Act, et cetera, contain an implicit provision like this?
Yes, Your Honor. So the Safe Drinking Water Act contains virtually identical language to this particular subsection E, and those are the only two provisions and this.
It has been held to bar removal? Is that what you're saying?
No, Your Honor, I'm not saying that. I will concede that I'm not aware of any statute that has been held to say that. I was simply noting that these provisions, or acknowledging that these provisions are idiosyncratic, and offering that perhaps that's a response to the concern that interpreting these provisions as the state suggests would sweep a wide range of cases into the state courts instead of the federal courts. And while I just want to be sure
you don't have some other case that interprets one of these statutes as speaking to this removal issue, do you?
Aside from the Ninth Circuit case that
interprets this. But that's
the
same. Okay, thank you.
Yeah. Yes. The other thing that I would note, one of the primary concerns that the United States raises in its brief is the risk that precluding removal in this case will mean that sovereign immunity is adjudicated in disparate state courts all across the land, and that is inconsistent with Congress's intent in revising the officer removal statute in 1996. But with respect, as I will turn to in a second, Congress believed in 1977 that it was broadly waiving sovereign immunity. The Congress of 1977, I submit, would be very surprised to learn that now, 50 years later, the United States was still coming up with creative ways to evade the broad sovereign immunity waiver that Congress thought it was enacting. So, of course, disparate sovereign immunity rulings in state courts can only be a problem that arises if the United States is raising sovereign immunity. And Congress made extremely clear in amending the Clean Air Act that it no longer expected the federal government would be raising those kinds of sovereign immunity defenses. It expected that it was broadly waiving sovereign immunity for all sanctions, including the one at issue.
So is your argument that removal is not permitted because sovereign immunity has been waived? I was a little confused by your most recent statements.
No, Your Honor, it's not that removal is precluded because sovereign immunity has been waived. It's that the United States points out that Congress, in amending the federal officer removal statute, stated that one of its concerns or one of its purposes was to make sure that sovereign immunity as a defense was adjudicated in the federal courts. It wanted to make sure that when the United States raised sovereign immunity as a defense, it was not being that 50 state courts across the country were not coming to different conclusions about the scope of certain waivers. And some saying punitive fines were allowed, and other state courts saying punitive fines were not allowed. And I was simply pointing out that given that Congress believed it had broadly waived sovereign immunity, it would not have anticipated that in state courts, the United States would even be raising sovereign immunity as a defense, and that would mitigate any concern about disparate state court rulings. Because of course you can't have disparate state court rulings about sovereign immunity if sovereign immunity is not raised as a defense in the first place.
But these are completely different issues, this removal and immunity, are they not? They stand independently. We have to look at them independently.
I think that's right, Your Honor, though I would, of course, note that...
Where'd y'all start this lawsuit? In Craven County?
Yes, Your Honor.
And how many counties are there in North Carolina?
100 counties.
100.
Now, I remember asking that in a criminal case one time, and I think I got the same answer. 100 different counties. So the United States could end up defending just in North Carolina lawsuits in 100 counties. Correct? If you're right.
Yes, Your Honor, that's correct.
As a practical matter, so you initiate them in the Superior Court?
Yes, Your Honor.
Okay. And
yes.
And the United States Attorney for Eastern North Carolina is in Raleigh, correct?
Yes.
And so he probably has 40 or 50 counties, and he has a real big division, big district. He'd be litigating all over Eastern North Carolina rather than just going on the elevator down to a different floor in Raleigh and to litigate. If you're right. If you're right, yeah. He's going to have to travel all over the district to litigate. Yeah. And then he could raise. You're saying he can raise this immunity issue, or try to, but you say he loses on that too. But just on the removal issue, your position would have the United States litigating separately in every county, not just in North Carolina, but in the United States of America.
Yes, Your Honor, that's correct. The upshot of our position would be that the United States has to litigate this in different state courts. But respectfully, Congress's concern in expanding the federal officer removal statute was never expressed to be one of convenience, to my knowledge. It was about uniformity in terms of federal defenses, and that's where my point comes in about Congress's expectation.
Well, it wouldn't be any uniformity to the rulings. You could have 100 different judges in North Carolina ruling on these issues, and then it could very well rule differently, and it could go to the Court of Appeals or the Supreme Court to try to get the federal issue resolved in North Carolina.
Yes, Your Honor. Yes, Your Honor, that's correct. There will be different rulings in the state, but again, if sovereign immunity is not raised as a defense, as Congress expected, then there's no risk of that with respect to the sovereign immunity issue. If I may, though,
I'd like to... The other issues, the non-immunity issues, would be raised and subject to different rulings in the different superior courts of the various counties all over North Carolina, not just the Eastern District, and all over the United States of America in the state court.
That's true.
The reason they got these removal statutes, all these, recall, I used to be in one of these U.S. Attorney's offices. We removed all kinds of things, was to give the government, the federal government, the opportunity to litigate in the federal court, and the uniformity that came from it.
That's true. That's true, Your Honor. That is certainly a concern of Congress's. If I may, I'd like to move on to the sovereign immunity piece and address briefly the Department of Energy.
Before you do that, Counsel, I thought one of the main thrusts of your argument with respect to removal was the obtaining any judicial remedy in state court language. And you hadn't addressed that yet. Are you waiving that argument, or do you still think that's valid?
No, Your Honor, we certainly think that that textual argument bears. From a purely textualist perspective, the fact that Congress used the word obtain is significant, and the United States has continued to fail to put forward any explanation as to what it means to obtain judicial remedies in a state court if the United States is capable of removing. So we would certainly still maintain that position. And we would also note that the United States has failed to identify what federal laws the words any law of the United States is in fact referencing if removal is off the table and sovereign immunity is off the table. So in adding that language to the statute, the state would argue that that means something, and that the straightforward textual understanding of that is that it references both the removal statute and the doctrine of sovereign immunity. If I may, I'd like to quickly move to sovereign immunity more broadly, though, and take on the Department of Energy decision, which I think we can all agree is the biggest obstacle to the state's position.
Well, can I ask you this? And I'll give you a little extra time because I know we've used up a lot of your time. I'll give some equal time to the government. But if you are incorrect with respect to the removal issue, the federal court below had no jurisdiction, correct?
If I'm correct, yes, that's correct. If I'm correct about removal, this case needs to be remanded to the state court, and the state court will decide the sovereign immunity question.
Well, how could it decide the sovereign immunity question when the federal government, and you're saying the federal government has to intervene to assert sovereign immunity?
No, the federal government is the defendant in the state court case as well, and presumably will raise sovereign immunity as a defense in state court as well. And then the state court will adjudicate sovereign immunity just as the federal court did.
Okay, all right.
So turning back to the Department of Energy decision, that decision does not control this court's reasoning for several reasons. First, of course, as the United States has acknowledged, the Clean Water Act contains no companion provision like the citizen suit provision that we've been discussing here. So the Supreme Court's careful textual analysis from Department of Energy simply has nothing to say on how the text of subsection E should be interpreted. That text is extremely clear and waives the United States sovereign immunity from all remedies and sanctions. And the United States has not attempted to argue that remedies should not naturally be understood to encompass punitive fines as well as coercive penalties. In addition, the Supreme Court in Department of Energy looked broadly at the statutory scheme of the Clean Water Act and noted that in the Clean Water Act, Congress had been careful in some provisions to exempt the United States from suit or from certain penalties, and in others had not. That is not the case with the Clean Air Act. In the Clean Air Act, the United States is broadly swept in as being subject to a wide range of penalties and fines, both in the statutory provisions that the state has raised, specifically in this case, and in other provisions. So I would direct the court both to...
Counsel, let me ask you a more direct question about the what could be seen as countervailing parts of the 7604E. The statute, it does say nothing in any law of the United States shall prohibit, but then it adds that sentence at the end for requiring compliance by the United States in the same manner as non-governmental entities, see section 7418. But 7418 appears to me to have that same process and sanctions terminology that existed in the Ohio case. So why isn't that the same limit here as it was in Ohio?
Stepping back, Your Honor, I think it's helpful to look at these two provisions as very much working in tandem. So 7418 is the provision that imposes this requirement that the federal government comply with requirements that the state has set to the same extent as private parties. 7604 is the mechanism that states and other private citizens use to enforce those requirements and those standards. So I do think it's useful to look at them in tandem, but I don't think that the language in 7418 is the only language that this court can look to. I think that the language in subsection E is extremely clear in waiving sovereign immunity. Of course.
Yeah, but the first part incorporates of 7604E, it at the end of subsection E, it incorporates 7418. And it says requiring, for the provisions requiring compliance by the United States, see section 7418. And what I guess I'm asking is that if 7418 applies to limit or give body to the rights in subsection E, why wouldn't the same limiting language in 7418 apply here as it did in Ohio?
A few different responses, Your Honor. First, the language in 7418 is not exactly the same in the Clean Air Act as the Clean Water Act. There is a specific sentence in the Clean Water Act that the Supreme Court examined that specifically limits the United States immunity and addresses the fact that the United States should only be held liable for penalties to enforce injunctive relief, which is exactly the kind of limit that we're looking at here. There is no comparable provision in the text of the Clean Air Act. There isn't any specific limitation on the United States liability. So that would be one reason that would counsel in favor of a different reason.
Ms. Boyce, I was going to give you 5 minutes and you're almost done. So maybe you can wrap it up.
Sure.
5 extra minutes.
Sure. Your Honor, Judge Agee, I do think that while these provisions work in tandem, the first part of that provision that we've been discussing, 7604, that says specifically that the United States can be sued by the state to enforce its air pollution laws, is a clear waiver of sovereign immunity that's completely separate from the sentence that follows it, cross-referencing it. Of course, in many federal statutes where courts have held that sovereign immunity has been waived, the way that Congress has done that is by expressly making clear that the United States is subject to suit and subject to specific penalties, and that's what this text does here. So I'll stop and reserve whatever time I'm able to have for rebuttal for later.
Thank you very much. You can keep your rebuttal time. I'm going to give the government 5.5 minutes extra if they want it right now. We'd be happy to hear from you, sir.
May I please court? Robert London representing the United States. I will go ahead and start with removal and just dive in there. One thing opposing counsel did not mention is the standard for removal. When we're talking about 1442A, the Supreme Court in the Watson case explained that it is to be liberally construed. So we're starting from a default here where the removal statute should have a liberal construction. And when we apply that and look to the argument that the state is making about taking that away, it falls short. First, as the court mentioned, the removal, the 7604E in the Clean Air Act just doesn't mention removal. So we're starting with a statute that doesn't directly address removal. Second, also as the court recognized, the legislative history here, removal was on the table. The original version of the bill said was going to prohibit removal by the federal government, and the conference report, as we explained in our brief, said we're dropping that. So we had for a brief moment, it looked like a statute that was going to say no removal, and then we didn't. And the broader picture here is it's sensible for this issue to proceed in federal court. It's an issue of federal sovereign immunity. Obviously, the federal courts and Fourth Circuit deals with that all the time. And it just makes more sense to read these statutes as leaving that issue to be decided post-removal in federal court. And rather than in the, for example, the 100 counties in North Carolina. I learned a new fact today. Jacksonville case in the 11th Circuit, looked at this carefully and we think got it right. It walked through the arguments essentially that the North Carolina is now making and rejected them. So we think the court should be guided by that Jacksonville decision rather than the decision on the 9th Circuit in the Sacramento case.
Counsel, can I ask you? Sorry, go ahead.
I was just going to say the problem in this case is that on either issue, whichever way you go, you have at least one court of appeals that's going to back you up.
Right. I mean, it's 1-1 right now. We think the Jacksonville decision is better reasoned, and we think it makes the points about there's no mention of removal here. Adding on to that, there are plenty of statutes, and we cite them in our brief, that expressly address removal. So, for example, 28 U.S.C. 1445 says the United States can't remove. And so we don't have that here. And I think that goes a long way to defeating North Carolina's argument.
Well, can I ask you the question I asked your colleague? Are you familiar with any other statute that implicitly or assertedly implicitly carves out an exception to the removal statute?
I'm not familiar. I'm not familiar with any other statute that a court has held implicitly blocks this federal officer, federal agency removal. I think counsel has it exactly right. You know, that the two similar statutes are the Clean Air Act, we're talking about it now, in 7604E, and then the Safe Drinking Water Act. And I looked, and I don't think either party has cited any Safe Drinking Water Act cases. I don't think there's any cases addressing it one way or another in that context. And we've already talked about the cases that address removal in this context. So I don't think there's an answer to that. I do think that, you know, you're not, to the extent you're finding an implicit, well, I think it's marginally better reading of the statute that maybe it blocks removal. That, I think, does run into what the Supreme Court said in Watson, which is the removal statute should be liberally construed. This removal statute, federal officer, federal agency removal statute, specifically. So even if you can kind of squint and find maybe an implicit stripping of removal, that's not good enough. I think it needs to be more than that, and it's not here. You know, as I think came up very briefly in the brief, North Carolina really focuses on the word obtaining in 7604E and says, well, we have to be able to obtain the remedy here, and that can't be done with removal. But I think on this point, the Supreme Court's opinion in Brewer is important. It looked at the word maintaining in the Fair Labor Standards Act and said, no, we're not going to read maintaining to mean you get to maintain the lawsuit all the way to the end. And I think it's, you know, a parallel argument really makes sense here with the word obtaining under the Clean Air Act. And so I think for all those reasons, you know, I think the removal point is removal makes sense here, and the statute just doesn't, the Clean Air Act in 7604E doesn't take it away. I saw Judge King pop up, so I stopped in case he had a question. I'll go ahead and go on. You know, the other main argument is sovereign immunity here, but I'm happy to answer other questions about removal before I go on to that. Because removal is proper, we think then this court and the district court properly moves on to the issue of sovereign immunity. And again, the state didn't mention the standard here, and it's, I think, really close to being dispositive here. Any waiver of sovereign immunity must be, quote, unequivocal, and that's been stated in a bunch of places, but the most relevant here, Department of Energy versus Ohio. Any ambiguities are construed in the government's favor, and if at the end of the day there is an ambiguity, then it's not an effective waiver of sovereign immunity. You know, in the opening brief, North Carolina started with 42 USC 7418, and we think that analytically makes sense because that does have a waiver of sovereign immunity. The problem with pointing to that waiver is it's indistinguishable from the waiver that in the Clean Water Act that the Supreme Court addressed in Department of Energy versus Ohio. And there the court very carefully walked through the language and at the end of the day said it does not waive sovereign immunity for this relief.
Well, how about looking at 7604?
Yes. So if 7418 doesn't waive, then the next place they look to is 7604E. And again, that doesn't include the unequivocal, unambiguous waiver that's required.
Yes, but it very, very clearly differs from the language that the Supreme Court was interpreting. Remember, the Supreme Court explained that because process limits the reach of the phrase, process and sanctions to coercive civil penalties. That's what it relied on. And indeed, that case, the court noted that the statute at issue expressly limits civil penalties. Here, process isn't married with sanctions, and it doesn't expressly limit civil penalties. And those were the two things that the court relied on.
Right. But I think that, just to be clear, that is, you know, that with respect to 7418, that's the same language. And so, but moving on to 74,
I thought we were talking about 7406.
I am. I just wanted to be clear that we were doing that. So moving on to 7604E, we're all on the same page. It doesn't first have the affirmative waiver that we're looking for. It's a savings clause. And you can
Is
tell
it
that
your position, is it the government's position that you have to have some magic language about affirmative waiver? Because that isn't the kind of analysis that the Supreme Court did in DOE, is it?
I don't think there's any one framing that gets you a waiver of sovereign immunity. That said, I don't know of a court finding outside this context what is a savings clause that reiterates twice that it's not taking away other rights, waives sovereign immunity, or is an unambiguous, unequivocal waiver. If you look at 604E in context, there's two other points. One, I'll just jump to the end because it came up in the opening argument. But as Judge Agee was pointing out, at the end of 7604E, it points back to 7418 for provisions requiring compliance by the United States, et cetera, in the same manner as non-governmental entities. See section 7418 of this title. And there we have the class.
But as Judge Agee, I think, also reminded counsel, the Seventh Circuit said that simply reminds the reader that 7418 defines the United States' burden to comply with state laws.
Right, and I think in defining that burden, it includes the required clear waiver of sovereign immunity, just not one that goes far enough to help the state here. The other point is, I think if you look in 7604 in context, in the whole, it's clear that E is not affirmatively waiving sovereign immunity. 7604A includes the citizen suit provision that does waive sovereign immunity for citizen suits in federal court. And the state could have brought such a claim, but did not. And third-party, non-governmental entities can bring that too. Then you have a bunch of provisions addressing venue, other matters relating to the citizen supervision. And then you get to E, and the title of E is non-restriction of other rights. So the thrust of the language that follows, the two negatively phrased, nothing in this section shall restrict provisions, or nothing in this section or any other law of the United States shall be construed to prohibit, are making clear that, look, just because Congress is saying, look, we granted a citizen suit provision, but in doing so, we're not saying we're taking away other rights remedies that you might have. But that's not the same thing as then saying, and by the way, we're waiving sovereign immunity in those other rights and remedies that you may be pointing to. And so
Counsel, if I could ask you, in terms of the first paragraph of subsection E, do you consider all of that a savings clause or just the first sentence?
I think the whole thing is a savings clause. I think the first sentence is addressed to one way that one could try to, a lawyer could try to say, no, you've granted a citizen suit right, and in doing so you took away some other right. And then the second sentence addresses another scenario. It doesn't.
Well, am I correct? And I may not be. I thought the 11th Circuit decision did not consider the second sentence a savings clause.
The 11th Circuit.
I may have that confused with another case.
No, I think you're right. The 11th Circuit's decision about 7604E says we think there is a waiver of sovereign immunity in here, but it doesn't apply to this suit because which was seeking a relief indistinguishable from what North Carolina seeks here, because at the end of the day, it points back to 7418, and that defines the scope of the waiver. So even if this is a fallback argument for the government here, even if 7604E has a waiver of sovereign immunity, our argument is, well, it's no broader than what's set forth in 7418 because that is more specific, and E cross-references to it at the end. And that's what the 11th Circuit concluded in the Jacksonville case. So we think the threshold decision of, well, does it waive sovereign immunity at all? We think it does not. So we disagree with that little part of the 11th Circuit's reasoning, but that court quickly went on and resolved the rest of the issue in the way we think is right. The other points we have made here that I think are worth looking to briefly are, the two cases from this circuit, the Virginia and North Carolina cases, do address 7604E And in doing so, while it doesn't address this issue precisely, I want to be clear about that, I think reading the opinions, I think one fair takeaway from them is that the court is not reading 7604E in those opinions as overriding other principles like sovereign immunity that might apply because of their independent standing.
So, counsel, am I correct that if this case, instead of involving a backward-looking or what the Supreme Court termed a punitive sanction, it was forward-looking and what they call a coercive sanction, you would agree that a coercive sanction is permitted?
Yes.
There is a waiver of sovereign immunity for that.
Yes. So 7418 waives sovereign immunity for a coercive sanction. So, for example, if the Marine Air Station here was still using coal, and North Carolina had an argument that it needed to make the conversion that it's already made, and was seeking an injunction requiring the boiler to convert to natural gas, then that would clearly fall within the waiver of sovereign immunity in 7418, and North Carolina would be able to secure that. But with respect to the violation is over, it's in the past, and we're seeking a punishment, a damages award that punishes the Marine base for that. That doesn't fall within the waiver in 7418, and that I think it's just that issue is resolved and controlled by Department of Energy versus Ohio. I think I have a little time left, but I feel like I've hit all my key points. So unless the court has any further questions, I would just close by noting, we think the removal here makes sense, the practical matter, and is supported by the liberal construction of the removal statute. And with respect to sovereign immunity, the state at most has identified some ambiguity in 7604E, but that ambiguity doesn't get them over the finish line. They need to show an unequivocal waiver, and 7604E just doesn't do that.
Thank you very much.
Thank you.
Did you reserve some time for rebuttal? You have to put
I
on
hope
your
so,
mic.
Your Honor.
You're on.
All right.
I'd like to jump.
We're going to limit you to the time, though, that you reserved, okay?
Yes, Your Honor. I'd like to dive immediately into section 7604E and the question of whether that's a clear waiver of sovereign immunity. At a high level, when the court is trying to figure out whether sovereign immunity has been waived, it asks both whether the United States has consented to be sued and what remedies are available. And the answers to both of those questions are clear in the text of 7604E. It makes very clear that the United States is an appropriate defendant that can be sued by a state, and it says that any remedy or sanction should be available. I did not hear Mr. Lundman make any argument that the word remedy would not ordinarily be understood to include punitive fines, and we think that text is crystal clear. To some extent, though, I think
the removal being upheld would include that at all.
the removal being upheld would send this case back to state court, where the United States could make its same argument about sovereign immunity and contend that it is immune from any punitive fines. But yes, Your Honor, it would preclude this court from coming to a conclusion on that particular issue. I do think to some extent this focus on the specific provisions 7604 and 7418 misses the broader picture, because of course the general question that this court needs to answer is whether Congress intended for punitive fines to be available under the Clean Air Act broadly against the federal government. And I think if the court expands its lens just a bit, the answer to that question is clear. We, of course, think there are clear signals in these two provisions, but there are additional signals in other portions of the Clean Air Act. And I would direct the court both to subsection A of the citizen suit provision, which makes clear that the United States can be subject to civil penalties in suits brought both by private citizens and states. So that would, of course, require this court to conclude that private citizens can impose punitive fines against the federal government, but that states cannot. And second, I would direct the court to 42 USC 7420, the non-compliance penalty provision, which also makes clear that states can pursue punitive penalties and punitive fines against the federal government. I would also note that in 1977, when Congress made these additional amendments, it also expanded the definition of the word person to include the federal government. Previously, it had only included private citizens, corporations, and states, and Congress deliberately expanded it to include federal agencies and officers. We would submit that the court did that, or that Congress did that, to make perfectly clear that the United States was subject to all of the fines and sanctions and remedies that are listed throughout the Clean Air Act. So all of these different aspects of the statutory scheme compiled together, we think make it crystal clear that Congress was contemplating that the United States would be subject to punitive fines. And of course, if the clear text of those provisions were not already enough, this court can look to the legislative history, which is quite distinct and clear in this particular case. And if I may, I'd read briefly from that. Congress said in amending the Clean Air Act in 1977, the amendment is also intended to resolve any question about the sanctions to which non-complying federal agencies, facilities, officers, employees, or agents may be subject. The applicable sanctions are to be the same for federal facilities as for privately owned pollution sources. This means that federal facilities and agencies may be subject to injunctive relief, to civil or criminal penalties, and to delayed compliance penalties. So of course, that makes clear that Congress believed it was even subjecting the federal government to criminal penalties, which we would argue obviously suggests that the punitive fines the state wishes to impose would be included as well. I also finally would like to note that, of course, Congress made clear both in 7604 and 7418 its intention that the federal government not have special status under the Clean Air Act, and that it be subject to the same requirements, sanctions, remedies as a private citizen. And there's no question that private citizens can be subjected to the kind of punitive fines that the state has sought to impose here. Those punitive fines are available both under federal and state law. So the state would submit that the federal government is not entitled to a special status, and that this court should avoid stripping the state of a very important tool in its toolkit for ensuring compliance with the state's air pollution laws and ensuring that the state's air quality standards are met both by private citizens and federal facilities. Thank you, Your Honors.
Thank you very much. We appreciated the argument from both counsel, and we will take the case under advisement. We're happy to hear argument in our second case as soon as the lawyers can get ready. We're happy to begin argument.
If it pleases the court, Your Honor. Michael Cohn, representing the relators Anham and Asadullah Sadr-Kale. This case is about the fraudulent extension of a contract that caused the government to pay $944 million more than it would have otherwise. The critical question is, did the government intend to terminate Supreme's bridge contract on December 22nd, 2012, as opposed to a later date? If the government intended to terminate on that date, then any fraudulent conduct that interferes with that intention is necessarily material. And so, turning to materiality, what establishes the December 22nd termination date is crystal clear. First, the first bridge contract, the government says as soon as a new contractor is able to perform, your bridge contract is being terminated.
Counsel, are you in the process of pursuing a fraudulent inducement claim or an implied certification claim, or both?
Both, Your Honor. But I think the materiality goes in this case to implied at the fraudulent inducement. And the fraudulent inducement that's going on here is the government had a contract with Supreme that was terminable at will. It was put in place so the government would have time to get a new contractor to take over supplying the troops in Afghanistan. The bridge, this contract was referred to as a bridge contract, the second bridge contract. It has a sunset provision in it that it would terminate automatically on December 12, 2013. However, it was a terminable at will contract, and the government issued what's known as a justification and approval, a J&A, that had to be signed off by the highest contracting authorities within the Defense Logistics Agency. And in that J&A, in black and white, in clearest terms, it says, no additional orders will be placed against the bridge contract once the new contractor can commence performance. So the actual termination date of the bridge contract was crystal clear. It would terminate necessarily the day Anham, who won the contract, could commence performance. And this was also set forth.
Well, counsel, if I could ask you, as I understand the record, the bridge contract was entered into prior to any of the alleged nefarious activities here. So if your argument is the government was induced originally to make the bridge contract, I'd like for you to address that. I take it from what you're arguing that there was some sort of an inducement later on not to terminate the contract. I'm not sure exactly what your argument is.
Yes, Your Honor. The inducement was to extend the bridge contract. There is no dispute that the bridge contract was being performed according to its terms, the pricing, everything that was in it. There is no dispute that it was being carried forward correctly. However, the bridge contract charged the government 44% more than Anham's contract would charge. And the government realized that if it could terminate the bridge contract as soon as possible, it was going to save a lot of money. In this case, in an 11-month period of time, the difference in charging between Anham's contract that it was awarded and Supreme's contract, the bridge contract, was $944 million in an 11-month period, the difference in cost to the government. So the government made it clear that it intended to terminate Supreme's bridge contract as soon as possible. And when they awarded the contract to Anham, it stated that the anticipated date that Anham would commence performance was December 22nd, 2012. Anham said, we can meet that date, and the complaint makes clear that Anham could meet the date, but for the fraudulent course of conduct that interfered with it. So in a contract extension situation, it's not the fraud when it happens in the formation of the contract, it's the fraud without qualification if it enters and taints the contract. You know, the Supreme Court said the fraud did not spend itself with the execution of the contract. Its taint entered into every swollen estimate. The taint, once the fraud enters into the picture, it taints everything after it. That goes for the fraudulent inducement claim. The implied false certification claims deal with mandatory integrity and business ethic responsibility determination, which is under 48 CFR 9.104. That responsibility determination is a requirement that the contractor must be able to meet the mandatory integrity business ethic responsibility. And if they can't, their contract must be terminated. In this case, we're looking at radically immoral conduct. We're looking at bribing government officials to establish a private militia that would go in and take the property of a contractor. The property that the contractor had a bill of sale for the land, had already spent $20 million to construct a warehouse on it, was in possession of the land for all over a year, and all of a sudden an armed militia pulls up with guns and kicks them all out of the site without any warning or anything. Without that warehouse, the Kandahar warehouse, Anham could not commence performance of its contract. Eventually, Anham went and got an injunction, and the injunction required all the other people to remove and for Anham to take control of its warehouse again. But the injunction couldn't be enforced because the government official responsible for enforcing it was on Anham's payroll and was paid bribes in conjunction with this case, and was at the signing of the fraudulent land transfer documents. So there is simply no way for the mandatory integrity business ethics responsibility determination to be made in Anham's favor, which meant they lost the contract once they engaged in that contract, period. More importantly, there was an ongoing bid protest that Supreme had initiated, where they were challenging the mandatory integrity business responsibility determination of Anham. And in that proceeding, they didn't identify that they were paying bribes. They didn't identify all of their fraudulent conduct. So that was an implied false certification to the government. And then kickbacks. You can't pay bribes on government contracts. That's also an implied false certification. The fact that there is proof, firsthand proof, that the bribes were paid. And then there's the Conduct Code of Business Ethics, which requires the contractor to timely disclose in writing when the contractor has credible evidence that bribes were paid to government officials. Well, there's more. It's the people who were meeting with the government, with DLA, or the people responsible for organizing and paying the bribes. They didn't tell the government they were paying the bribes. So I think that satisfies the implied false certification.
What did the criminal prosecution that you stick in the appendix have to do with this?
I'm sorry, I didn't hear the question.
You have there's an indictment or an information in the appendix. I say, what did it have to do with this?
I think that would just be prior bad conduct, but it's not germane at this point.
Well, then what are you doing putting something in the record here that doesn't have anything to do with it? So you admit it had nothing to do with it?
Well, no, I think it sets...
well, you said it's not germane, that's pretty much...
Well, let me rephrase. It's prior conduct in the contract that Supreme was attempting to continue on with. It had been sanctioned by the government for prior False Claims Act activity. It just shows prior... and the same people who were identified in that complaint, some of them are the persons in this case. So it just shows, prior bad acts.
Counsel, let me ask you a question about your materiality argument. In Escobar, the Supreme Court talked about materiality, and one of the qualifiers it listed was that if the government pays a claim despite actual knowledge that requirements were violated, that's strong evidence that the requirements are not material. Well, if I'm remembering the record correctly, here the Anham had told the Defense Department quite a bit about what they alleged that Supreme had done, but yet the government kept paying them. So why wouldn't that take you out of materiality under Escobar?
Because The government did not have actual knowledge, which is the Escobar standard. The DLA, the government attributed what Anham claimed to be bad acts on the part of Supreme. They sent an email to Anham saying it's no more than proffered excuses. So there was no, and Anham admitted it had no actual evidence of any fraudulent acts on the part of Supreme. The only time, what happened with the actual knowledge is when the other relator, Asadullah Sadr Kale, who is the linchpin of this entire case, he is the brother of one of the named defendants. He is in the room when the fraud scheme happens. He gets to hear it all. He knows that they're going to seize the warehouse. He knows they're going to pay bribes. He knows how the money was transferred. He was a bag man and brought $100,000 to one of the government officials as a bribe. And that relator came forward much later. And it was only after that relator came forward that Anham obtained actual knowledge of what the fraud was. And that is a point in time, the filing of this complaint was the first time the government actually obtained actual knowledge of the fraudulent activity.
You don't have to use all your time.
I'd like to point out, the Wilson case, which is very, very important. It establishes the objective falsehood standard. The fraud, the proof of the fraud has to be true or false. It has to be empirically verifiable. And in this case, the fraud hinges on whether or not Anham owned the land and the warehouse, or did Supreme own the land and warehouse? It's a binary on and off situation. It meets the objective falsehood standard. So, and we have Supreme openly discussing its need to take control of the warehouse to prevent the government from transitioning to Anham. We have Anham in possession of the actual bill of sale for the property a year before anything happens in June 11. You have Anham physically on the property for an entire year, during which time they construct a $20 million warehouse. And all of a sudden, without any knowledge, warning, notice, or anything, an armed militia shows up with guns and they kick all their security people and all their contracted people out of there and take over their warehouse. Not a single piece of paper, not a peep from anyone, okay? And why does this happen? Because Supreme secretly wires $20 million to its subcontractor to give money to the former landowners just for them to say, hey, we're going to sell it to you now. Supreme had no business need for the warehouse. Supreme didn't account for the $20 million in the corporate books for several years. The transfer document, there was no actual agreement in place for the $20 million. That didn't happen for several years later, if it ever took place. They had to pay bribes to government officials in order to get their armed militia in there. And Anham got an injunction from the Afghan government requiring that the property be returned to Anham. And when Anham sought to enforce the injunction, the government official responsible for giving that relief to Anham was on Supreme's payroll and bought off. And they couldn't get possession of their warehouse. So what did Anham have to do? They ended up building an entirely new warehouse at a separate location. And it took them about a year to get that together. And during that course of that year, the government was charged $944 million, more than it would have if Supreme hadn't sent a militia in there to seize the warehouse. It's that simple. I'm pretty much done with my time, but I think I reserved 3 minutes for rebuttal.
Thank you very much. We'll be happy to hear from Mr. Bickleiter. Do I have that right? You have to put your
You're on mute.
No, I'm not.
Now you're not.
Yeah, thank you, and you did pronounce my name correctly.
Great.
Your Honor, let me start, Your Honor, by saying that so many reasons this case doesn't fit as a False Claims Act case. That's not just being rhetorical. I'll get to I have at least 7 points which say that, and all backed up by decisions of this court. But let me start off with 2 of Judge Agee's points, because I think they're important. One is the question about the timing. In this case, this is the first case that I've seen that I've looked for them, where the fraud takes place after the inducement. It's impossible. Fraudulent inducement requires that there be a fraudulent representation, a material fraudulent representation during the time that the agreement is being formed, the formation of the agreement. Here, 5 months elapses between the June 2012 second bridge and the actual and the actual frauds that are being asserted. And 5 months makes it impossible. And Your Honor should understand, there was no other agreement. The second bridge is itself an extension. Mr. Cohen averts to an extension. There was no extension beyond the second bridge, which again occurred in June of 2012. But the frauds occur beginning in November of 2012. So for that reason alone, Your Honors, the contract could not have been fraudulently induced. The law is clear that the cases in this circuit, including Harrison 1, they all involve traditional allegations of fraud in the inducement. Namely, as I said, the fraudulent agreement or extension occurred before the fraud. There's a fraud, then then a contract extension or modification. As Judge Alston concluded, because fraud in the inducement is concerned with whether the contract or extension of government benefits was obtained originally through false statements or fraudulent contracts, citing Wilson. A supposed fraudulent act 5 months later cannot possibly be a fraudulent inducement.
Let me ask you something, sir.
Yeah.
What did the Department of Justice, the Attorney General, say to you about this lawsuit?
Well, Your Honor, they said nothing. They declined to intervene. And as Your Honor,
right. They filed a notice of election to decline intervention.
Precisely.
Correct?
Precisely.
What did you notice? What did that notice say? I look for it here in your appendix. I don't find it.
It was a simple declination, as far as I can recall, Your Honor. We declined to intervene. It may have said more, Your Honor. I've got to be honest. I had not looked at it recently, but I believe it simply said we declined to intervene.
The complaint was served on the Attorney General.
Precisely, Your Honor.
And he declined to, that was he then, he declined to get involved. And it was not until after that it was served on your client, correct?
Correct. After the intervention was.
But you don't know, then you don't have any idea what the reasoning of the Department of Justice was.
I have a good idea, Your Honor, but I can't. But it wasn't in writing, so I can't. It would be.
I'm sorry.
I have a good idea, but it's not in writing, Your Honor. So I'm not gonna repeat what I was told. But what I will say is this, Your Honor, that in Triple Canopy, which was a case in which you were on the panel, Your Honor pointed out, or the panel pointed out two factors which led to a finding of, which led to a finding that there was no materiality. One was that the government continued to pay under the contract, which is exactly what happened here. After twice, the head of the agency, Admiral Harnachek, met with Supreme and met separately with Anham. The Admiral decided to continue doing business with Supreme, which is not surprising since Supreme was in. The second bridge had a term, an expiration date. The expiration date had not been met, and he continued to do it. And by the way, along the way, Admiral Harnachek said that with regard to the allegations made by Anham, that there were no smoking guns. And that, as Mr. Cohen pointed out, he also said these are excuses being proffered by Anham for its not being ready to perform under the contract. So we have the two things that Your Honor pointed out, that was pointed out in the Triple Canopy case. We have the government continuing after it was told by after the head of the agency was informed, continuing to pay. And we have a failure to intervene, a refusal to intervene by the government. I mean, there's a lot more here going on in terms of materiality, Your Honor. It's not material because there's no connection here between any of the acts that are alleged to have been committed by Supreme, which of course are denied, and any payment decision. No, there's no connection, and Judge Alston correctly pointed that out. What we have here instead, Your Honor, is we have a whole series of you engaged in this fraud, you engaged in that fraud, but that's not the law. The law is not the underlying frauds that count. It's whether or not, it's not whether the underlying frauds, but whether the statute attaches liability not to the underlying fraud, or to the government's wrongful payment, but to the claim for payment. That was in Harrison, and more recently in U.S. XREL Grant versus United Airlines. It has to be an allegation that the underlying fraud caused a payment decision in some way, influenced the payment decision. And it just isn't there, Your Honor. You guys can look. Judge Alston didn't find that, and he based a large part of his decision on the fact that those necessary allegations, that there be a connection between the so-called frauds and a payment decision, just aren't present. Not present on the fraudulent claim and conduct allegations, and they're not present on the implied false certification allegations. Indeed, Your Honors, with regard to the pleading in hindsight, which occurred here, what the appellants do is they say, look, we now realized that that there was fraud beginning in November 2012, and that has a retrospective impact on the claim on the contract on the second bridge, which was entered into in November, in June of 2012. Well, this court again says you can make mere allegations of fraud by hindsight will not satisfy Rule 9b. As a matter of fact, Rule 9b is not satisfied for many, many reasons. If you look at the complaint, you won't find the who, what, when, where, or how. You won't find the allegations which are the basis of the implied false certification. You won't find who said them, when they were said. You simply have speculation, conjecture, which doesn't meet Rule 9b. It doesn't meet Iqbal. It doesn't meet any of the requirements that are required. Mr. Cohen brought up the question of whether there was an objective falsehood. Judge Alston dealt with that correctly. Judge Alston looked at the complaint as pled and saw that the Admiral Harnachek, the head of the agency, had found that there was merit, or at least were arguments on both sides to the ownership of the property. That clearly is a good basis, and that also is a basis for that there's no materiality here. If in fact the agency believed that this was just simply a two-sided dispute, one side claiming the parcel of land, the other side objecting, saying that they have the right to the land. That is simply there is no objective falsehood. If as occurred in Wilson, there is a dispute as to some subjective analysis, some subjective finding.
Counsel, I understood Mr. Cohen to make an argument with regard to fraudulent inducement that there was an inducement during the term of the bridge contract not to terminate it prior to its end date. What's your response to that argument?
Your Honor, the simple response is he didn't plead it in his complaint. There's no allegation which says on such and such a date, in front of such and such a body, in front of said by Mr. X or Mr. Y, an inducement was made. There's no fleshing out of an inducement. None. Zero. In the absence of those kind of particularities, particular allegations, Judge Alston was correct in saying that there's no basis to let this case go forward. It was up to the relator to provide with particularity, to allege with particularity those allegations, and they just aren't there. So there's nothing, and again, remember, Your Honor, there's no platform, there's no time between from the time that they say that the fraud began, which is November 2012, until when the government actually terminated the contract in November 2013, about 3 weeks or so before the expiration date of the contract. There was no platform, there was no opportunity for a false statement with regard to which could result in fraudulent inducement. It just wasn't there. There's no place for it, and they certainly don't assert it. They certainly don't make the allegations that are necessary for a fraudulent inducement.
You don't have to take all your time, sir.
Let me just make a couple of more points.
Sure.
First of all, Your Honor, I thought this. In the implied false certifications, there's no question here, but that there's an absence of an allegation. Take a look at the complaint, which would lead to the basic fundamental assertion that Supreme made any representations which were contrary to any material contract or regulation. They just aren't there. What they do instead is they assert certainly nothing with regard to the contract, because the contract, there's no provisions of the contract at all that are cited in the second amended complaint. And with regard to the regulations, they just have nothing to do with this case. There's an argument that there was, as Mr. Cohen said, that somehow there was a kickback. The kickback provisions only relate to actions by subcontractors trying to get favorable treatment from the prime contractor. That's not the situation here. They assert that a regulation which requires that an applicant's behavior, previous behavior, be reviewed when it's up for a new contract. But Supreme was an incumbent, so that regulation doesn't work. And then they have they cite a provision, a regulation, which requires the contractor to disclose any violations of Title 18. They haven't cited any violations of Title 18 here. What the violations were the violations of Afghan law or other provisions, but not Title 18. So none of those provisions, since they don't apply, the second prong of the Escobar test for full certification cannot be met. There's simply nothing here which asserts, which would make Supreme liable for violation of any of the regulations or the contract. Full certification just doesn't apply. Let me just, I'll finish with this, Your Honor. This is at heart, at bottom, a contract dispute. Anham won the contract. They were the successful bidder. Now they're claiming somehow that Supreme violated a contract and regulation. But that's not what happened. But that's not what's required here. They have to show that this is more than just a dispute among competitors. In both Owens and Wilson, Judge Wilkinson wrote that you cannot shoehorn a contract, a business tort and make it into a false claim. And that's what's happening here. They've taken some business courts directed, they say, against them, but not against the United States. And that's an important distinction. And they try to shoehorn it into a False Claims Act case, which this court should reject. If there are no further questions, I will turn this to Mr. Cohen.
Thank you very much. Mr. Cohen, do you have a rebuttal? You have to take yourself off mute. Okay, good.
I'd just like to point out that in Harrison, it is clear, it clearly states that it reaches any fraud without qualification. Okay? The fraud did not spend itself with the execution of the contract. It pays everything afterwards as well. FCI liability attaches when the claim is submitted, not when the fraud occurs. So the fact that trying to say the fraud has to occur during the contract formation doesn't make sense if it's the timing of when the fraud occurred. In Wilson, they were claiming the fraud, they were 5 months reversed. Here, the fraud occurred with the seizure of the warehouse, and it's the claims that were submitted after seizure of the warehouse that are actionable. The liability attached not when the fraud occurred. All that's necessary is that the fraud precede the submission of the claim. And here the fraud and once the fraud seeps in, it doesn't dissipate. Every claim filed afterward is automatically tainted. Most importantly, the government made clear to Supreme that no additional, this is black and white in their statements, no additional orders will be placed against the bridge contract once Anham's contract is in place. And the government told Supreme and Anham that Anham's contract would be in place as of December 22nd, and it would have commenced on that date, but for one thing. If you ask, why didn't the bridge contract terminate on December 22nd? If you read through everything that's in this record, there is only one reason why. Supreme sent in a military force and took Anham's property. And we claim, and it's an on-off binary choice. Did Anham own it? And if they did, then it was per se fraudulent conduct. I think with regards to Admiral Harnachek, misleading the Admiral does not give you a pass. That's part of the fraud scheme. The who, what, when, where, and why. One of the whistleblowers, Asadullah Sadr Kale, was in the room when the fraud scheme was hatched and knew everything about it. Everything about who, what, when, where, why is laid out in excruciating detail in the complaint. My time is up. Thank you.
Thank you very much. We'll take the case under advisement and go directly to our third case.
Judge Motz, can we take a very brief stretch break?
We certainly can.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Good afternoon. We're happy to hear argument in our last case today, Moreno Osorio versus Garland. Mr. Valera?
Good afternoon, Judge Smalls. Good afternoon, Judge Aki. Good afternoon, Judge King. I'm deeply honored once more to present oral arguments for this court for the fifth time, and hopefully I'll be able to achieve immigration justice for my client, the petitioner. Your Honors.
Try to do it in every case.
Yes, Your Honor. Your Honor, the petitioners brought 4 issues before this court. The first important issue is whether the Virginia Code 18.2-51 unlawful wounding, a crime of violence, and hence an aggravated felony under INA 101A 43F that bars petitioner from asylum relief. Now, in resolving this issue, Your Honors, we submit that the Castleman, the United States versus Castleman case decided in 2014 should not be applied. More specifically, the Castleman's holding that the knowing or intentional causation of bodily injury necessarily involves the use of physical force should not be taken out of its context and applied here. It should not be applied here, Your Honors, because the physical force referred to in the Castleman is the common law offensive touching force and not the violent force under Johnson. Which,
Counsel, you're familiar with our decision in Rumley, right?
Yes, Your Honor. And
2020 decision, which directly rejects that argument, right?
Yes, Your Honor. But what we are arguing here, Your Honor, is since the case of Rumley is based on Castleman and the Castleman issue, and the case relative to Rumley pertains to the enhancing provisions of the Armed Career Criminal Act, this should not be applied here specifically in cases of immigration. And the reason for that, Your Honor, is that when Castleman was decided by the Supreme Court, it incorporated the common law meaning of force, namely offensive touching under 921A 33A's definition of misdemeanor crime of domestic violence. And the rationale of the Supreme Court then said that we began by observing that at common law, the element of force in the crime of battery was satisfied even the slightest offensive touching. And we recognize the general rule that a common law term of art should be given its established common law meaning, except where that meaning
Counsel, if I could interrupt you for just, is your argument that Rumley is wrongly decided?
No, Your Honor. No, Your Honor. What we are arguing is it should not be applied in this immigration law because, in this immigration case, because the physical force under 18 USC 16A pertaining to the term crime of violence is the violent force contemplated in Johnson and not the Castleman physical force that includes the presumptive common law definition. Now, in this backdraft, Your Honor, what we are submitting is under the 18 USC 16A, defining the crime of violence as an offense that has an element, the use, attempted use, or threatened use of physical force. Castleman's holding should not be applied as this was made within the context of misdemeanor domestic violence crimes due to the unique nature, Your Honors, of domestic violence under 18 USC 92G9. And the purpose of which is to close, according to the Supreme Court, is to close a dangerous loophole in the gun control laws where many perpetrators of domestic violence are convicted only of misdemeanors, when all too often the only difference between a battered woman and a dead woman is the presence of a gun. It should not be applied within the context of the Immigration and Nationality Act, which has its own species, Your Honors, of crimes that have different effects. Like, for example, there are crimes that are considered crimes involving moral turpitude offenses, which, though a ground for removal, is not a ground of ineligibility for asylum, and aggravated felonies, which is both a ground of removal and a disqualification of asylum. Now, with this conviction of the petitioner, he was, in fact, disqualified and barred from seeking the relief of asylum because of the context of unlawful wounding. Now, as we pointed out, Your Honor, in our briefs and citations, while bodily injury comprehends, it would seem, any bodily hurt whatsoever, breaking the skin, for example, not required. While the statute does not define bodily injury, courts have been reluctant to give juries a definition because of the phrase such an everyday ordinary meaning, which means, as pointed out in the Castleman, Your Honors, it is hard to describe as violence a squeeze of the arm that causes a bruise. Yet a bruise would be encompassed by bodily injury. Now, since bodily injury may be inflicted without using violent force, then the use of physical force, that is violent force, is not a necessary element for Virginia 18.2-51 unlawful wounding. And consequently, Your Honors, unlawful wounding is categorically not a crime of violence, which brings us to the context that even in the case of Castleman, when it was brought before the Sixth Circuit Court, the Sixth Circuit Court applying Johnson versus the United States in 2010 requires violent force, holding that Castleman's conviction did not qualify as a misdemeanor crime of domestic violence, as Castleman could have been convicted for causing a slight, non-serious physical injury with conduct that cannot be described as violent. But of course, the Supreme Court made a ruling on the crime of violence, but still, the fact remains that it applies mainly to domestic violent cases. That's why the intent of Congress on the crime of violence, Your Honors, is that it is the use of violent force. That's why there are different immigration consequences relative to a particular offense, whether it will be classified as CIMT or a crime involving moral turpitude, or whether it will be classified as an aggravated felony. But here, misdemeanor domestic violence, because of the unique circumstance of domestic violence, is considered an aggravated felony. So Romley is good and correct, Your Honor. Although it cited Castleman, what we would like this court to do is not to apply that in terms of petitioners being barred from applying for asylum, for which, according to the decisions of the judge and the Board of Immigration Appeals, is only entitled to apply for withholding. Now, this brings me also on the second issue, which maintained that the board committed a reversible error in holding that what happened to petitioner does not rise to the level of persecution. Without stating its own reasons, Your Honor, the board agreed with the immigration court's findings that what happened to respondent was not persecution, as it does not compare to the factual circumstances in the cases of Avalos versus Lynch and Valladares versus Holder, where the respondents were threatened 3 times by gang members with guns pointed to their heads. And according to the immigration...
What about your particular social group here, which would apply both to asylum and withholding of removal? If you don't have a valid particular social group, I don't think we get to any of the other issues on those 2 items, do we?
That's correct, Your Honor. Precisely, our position is that it's a reversible error for the board to maintain that petitioners' PSG or particular social group do not meet the particularly particularity requirement. Now, the particular social group here is returning arriving migrants, and it does not lack this particularity relative to the context of the case of Amaya versus Rosen. For example, Your Honor, we just received
let me
yesterday.
ask you just for an example here. As I got this from the BIA and IJ decisions, the particular social group identified was individuals returning from the United States or returning migrants from the United States. Is that correct?
That's correct, Your Honor.
Well,
So
how can that be?
if someone
Go ahead.
someone from Honduras goes to Disney World and they visit Disney World and they come back, they're an individual returning from the U.S. or a returning migrant?
Well, Your Honor, again, the context of the returning migrant or immigrant in terms of the petitioner's case refer to groups of people who have been deported or who have been removed from the United States. In a sense, you can say that they are considered arriving migrants or returning migrants if they return. But that particular example would not fit in within the context of what we are trying to expound.
But
here.
how do we tell that from the language that you use, though?
Well, Your Honor, with respect to the broadness, if we look at the decisions decided by the Circuit Court of Appeals, for example, on Perdomo versus Holder, the size and breadth of a group alone does not preclude a group from qualifying such as a group. In fact, as I was mentioning earlier, Judge, Your Honor, in Amaya versus Rosen, we fail, according to the court, we fail to see how this reasoning of the BIA, well, it rejects that argument that pertaining to the subdivision, or you are furthering subdividing the group in any number of ways by age, sex, background, or by level involvement with a gang. So what the court is saying is that there are smaller group parts to any whole. What matters is not whether the group can be subdivided based on some arbitrary characteristics, but whether the group itself has clear boundaries. Now, in the case of the petitioner, if you look at the facts of the case, and this, it's crystal clear that when he returned to Honduras, a day after his return, he was immediately identified and was threatened and basically forced him to leave. Now, the Honduras government, Your Honor, specifically recognized this particular group of people, in fact, assisting by virtue of their decree, assisting returning migrants to Honduras, considering the nature and context of the danger that they are facing if returning to their country of origin. And we submit, Judge, that the respondents' proposed PSG of returning arriving and returning migrants, based on the yardstick of Amaya, the legal standard is not what the government is saying, that whether or not the group has clear boundaries with objective goalposts delineating the boundaries to the group. Instead, what Amaya is saying, as I've mentioned earlier again, is the fact that it could further subdivide the group in any number of ways, and it only points out that there are smaller parts to any whole. So what matters, again, is whether the group can be subdivided based on some arbitrary characteristics, but whether the group itself has clear boundaries. So in the first instance, the government utilized the wrong standard. That's the reason why it constitutes a reversible error. And this is the one being sent that was sent to your representation yesterday relative to the supplemental authorities, Judge. Now, the context of broadness with regard to the case, notably of the case of Galdames versus Holder, the court noted the admission of the government that the particularity requirement is not an attempt to impose a numerical limitation on the size of a particular social group.
Counsel,
Particularly,
your time has expired, and I've even let you go a little over. You've reserved some time for rebuttal, haven't you?
I'll reserve my time for the rebuttal.
So we'll hear from the government, and I think we understand the gist of your argument.
Thank you, Judge.
Thank you. Ms. Freya?
Good afternoon, Your Honors. Allison Freyer for the Attorney General, and may it please the court. In this case, there are 3 applications for relief and protection at issue: asylum, withholding of removal, and protection under the Convention Against Torture. Because the agency did not err in denying any of those applications, the petition for review should be denied. First, with respect to the asylum application and the crime of violence finding, petitioner's argument here that the statute of conviction does not necessarily involve a sufficient level of force has already been rejected by this court in Rumley, and his attempts to cabin that reasoning to the ACCA are not persuasive. The language of the ACCA violent felony provision and 18 U.S.C. Section 16A are nearly identical. And to the extent that they differ, Section 16A is actually broader because it permits crimes to be a crime of violence if the force is used against the property of another person, whereas the violent felony provision requires force to be used against the person of another. So any violent felony will necessarily be a crime of violence as well. And the Supreme Court's decisions in Johnson and DiMaia illustrate that fact. The court applied its decision in Johnson to the immigration context in DiMaia without any difficulty or need for great discussion. And the same should happen here. Rumley controls. Moving on to the withholding application, the question of the cognizability of the particular social group is dispositive of the entire application for withholding of removal. And therefore, the court need not reach the question of whether Mr. Moreno Osorio was subjected to past mistreatment rising to the level of persecution. The agency properly found that his proposed group was not sufficiently particular. The group that he proposed before the agency was returning migrants from the United States. This court should reject any attempt to finesse or change his group at this late stage. Any such group would be both unexhausted and waived. The agency was correct in determining that that group lacks sufficient particularity. The board noted that Mr. Moreno Osorio claimed that the IJ was improperly concerned about the size or breadth of the group, and the board properly rejected that argument, saying that the IJ did not consider only the breadth of the group, but also whether it was clear who was in the group and who was not in the group. The question of clear benchmarks or objective goalposts has always been a very a critical part of particularity, and the agency properly ruled that those terms are not clear on their face. They are not a sufficient benchmark for membership. In his brief, Mr. Moreno Osorio asserted that those terms have clear meanings, but he never provided them, probably because the government's position is they do not actually have clear meanings that would be the same to everyone. Moreover, the agency did not err in ruling that the threats did not rise to the level of past persecution. The record does not compel that conclusion. Mr. Moreno Osorio was threatened on one occasion by a group of men who did not know his name until his cousin told them. They did not know that he'd returned from the United States until his cousin told them. They did not attempt to harm him or even threaten him with their weapons. They didn't know where he lived. They didn't know his phone number. And so that single threat does not rise to the level of persecution. The law is clear that persecution must be severe and the record cannot compel the conclusion that that single incident rises to the requisite level of severity. Finally, with respect to cat protection, the record does not compel the conclusion that the Honduran government would acquiesce in any future torture of Mr. Moreno Osorio. The police accepted a report from Mr. Moreno Osorio's aunt. Although Mr. Moreno Osorio believes they did not investigate the report, it's not clear exactly what the police could have done under these circumstances. By the time his aunt reported the incident, Mr. Moreno Osorio was here in the United States. More than a year had gone by since the incident. And so without a victim or proximity in time and place to the threat, there wasn't much that the police simply could do. They accepted the report. They did not attempt to turn Mr. Moreno Osorio's aunt away. And therefore her experiences demonstrate that the police would help Mr. Moreno Osorio upon return should he need it. Moreover, Mr. Moreno Osorio relies on threats to his aunt to suggest that the police acquiesce in the gang's activities. But Mr. Moreno testified that the threats to his aunt dealt with him, not with her, and therefore she was able to safely report a gang crime to the police without experiencing any problems with the gang as a result of that report, also undermining that the police would not acquiesce in the gang's activities. Generalized country conditions of corruption and impunity are certainly troubling, but they are insufficient to compel the conclusion that Honduras would acquiesce in the gang's activities, particularly where the record shows that the Honduran government has taken specific, concrete, effective actions to deal with corruption in its ranks. Those were all the points I wanted to hit. Are there any questions from the bench?
I don't think we do have any questions. We thank you very much for your argument.
Thank you.
Mr. Valeria, you have a rebuttal, I think?
Yes, Your Honor. This will
3
just
minutes.
be a short rebuttal, Your Honor. It is true that this was a single occasion as compared to the 3 occasions in Hernandez Avalos versus Crespin Valladores. But nothing in the decisions of the Fourth Circuit, Your Honors, requiring that the applicant be threatened twice with pointed gun to the head before he can be deemed persecuted. The decisions of this court are clear. Death and threat of death constitutes persecution, and clearly this is the case here. Now, with respect to Amaya versus Rosen, the government cannot use the reasoning based on that Amaya versus Rosen because the BIA and the immigration judge made a decision stating that there is no particular social group because it is too broad and it is diverse. Amaya's test or legal standard is whether the group has clear boundaries with objective goalposts delineating boundaries to the group. Now, with respect, Your Honor, to the Convention Against Torture, we have submitted sufficient evidence to show acquiescence of police authorities to his torture. And in fact, it is true that country conditions, the impunity is an integral part of proving acquiescence of police authorities. But in this particular cases, Your Honor, we have submitted court cases where it indicates, for example, where there is an inability on the part of the government to control. Like, for example, what happened in Los Cetos, a typical gang group or drug cartels, and they failed because of the corruptions and the connections of these cartels to the government and to the police, then obviously it is a clear indication of acquiescence. And we have submitted that this has been corroborated by the country reports of our government, showing the increased murders where they have elevated Honduras as the murder capital of the world, and the failure on the part of the government to seriously address the issue of corruption of the police force. So in this context, Judge, I do believe that we have a case for a remand and a reversal so that the petitioner, number one, on the context of the conviction of unlawful wounding, it should not be classified as a crime of violence and hence an aggravated felony that disqualified him from the asylum relief. And then, of course, basically the context of the issue of particularity, which the BIA and the immigration judge, as indicated by the supplemental authorities presented by the government, are not actually the standards set forth in Amaya versus Rosa. Thank you.
Thank you very much. We'll ask the clerk to adjourn court. We thank you for your arguments and stay safe.
Stay safe, Your Honors.
This honorable court stand adjourned until tomorrow morning. God save the United States and this honorable court.